When we talk about crime, we almost always focus on the action itself, right? The physical act.
Yeah, what actually happened?
But deep beneath the surface, the law asks this really fascinating question. When is a criminal action, legally speaking, not actually a crime?
That's where it gets complicated and interesting.
Welcome back to the Deep Dive. Today we're getting into something absolutely essential in law. Our mission really is to dissect Chapter 8 of the Texas Penal Code.
The general defenses.
Exactly. This is where you find the rules that look at culpability. It's where the law steps back from just the action and looks deep into the mind of the person involved.
Right. Their intent, their capacity, maybe extreme circumstances.
Yeah.
Things that could override their choice, you know?
So we're going to try and quickly but thoroughly unpack these legal concepts. The goal is to give you, the listener, a really clear picture of where the state draws the line, between a guilty mind and an action that's maybe justified or excused.
Yeah, this is the stuff that gets sensationalized a lot in courtroom dramas.
Totally. But we're going to look past all that drama and get straight to what the law actually says, the statutes themselves.
The black letter law.
Right. Now, before we really dive into the specific statutes, just a quick mandatory word for you listening. If you find this helpful, us taking these dense, complicated legal documents and making them hopefully easier to understand.
Giving you the shortcut.
Yeah, exactly. Then please subscribe. Your support genuinely helps us grow, and it means we can keep putting the time in to create these detailed deep dives.
And don't forget the website. We put supplementary material up there related to the cases and concepts.
Definitely check that out. Okay, so that support is vital because the stuff we're tackling today, it's really fundamental to criminal justice.
It absolutely is. And maybe the very first thing you have to get your head around before we even start looking at specific defenses is the difference between just a plain defense and what's called an affirmative defense.
Okay. That sounds technical, but important.
It's crucial. It determines who has to prove what in court. It can decide who wins and who loses.
All right, let's unpack that difference then, because it sounds like the legal weight shifts depending on which one it is.
It completely shifts.
Yeah.
It all comes down to the burden of proof. So think of a standard defense, maybe like self-defense or mistake of fact, which we'll get into.
Okay.
The standard defense, its only job is to raise reasonable doubt about something the prosecution already has to prove anyway.
Like intent.
Exactly. Like if the prosecution has to prove you intended to steal a car, but you argue, hey, I reasonably thought it was my rental, you're attacking their proof of your intent.
So the burden stays with the state. They still have to prove I meant to steal it.
Precisely. The burden never leaves the state. They must prove every element, including that intent, beyond a reasonable doubt.
Okay, that makes sense.
But an affirmative defense is different. Totally different game. And Chapter 8 is full of them. Insanity, duress, these are common examples. With an affirmative defense, first, the prosecution does its job. They prove every element of the crime beyond a reasonable doubt. Let's say they do that.
Okay, so guilt on the act itself is established.
Right. Then the burden shifts entirely. It flips over to the defendant. Now, the defendant has to prove that the affirmative defense applies.
And how much proof do they need? Is it still beyond a reasonable doubt?
No, and this is key. Usually it's by a preponderance of the evidence.
Okay, so beyond a reasonable doubt, we hear that all the time. Sounds like maybe 99% certainty. What's preponderance of the evidence mean practically?
Think of it as the more likely than not standard, like 51%. The defendant just has to convince the jury that the facts supporting their defense, say insanity, are slightly more probable than the facts against it.
Huh. So it's a much lower bar for the defendant. Why is that?
Well, remember, the prosecution has already proven the person committed the act. The law just needs sufficient reason to believe this exceptional circumstance, like insanity or being forced, was actually present. It's kind of a check.
Got it. So state's high burden first, then defendant's lower burden for the affirmative defense. That distinction feels really important for understanding what follows.
Absolutely crucial. Keep that difference in mind as we go through these.
All right, with burden of proof clear, let's start with defenses focusing on the actor's mind, their capacity, and we have to start with the one everyone knows or thinks they know. Insanity, section 8.01.
The big one. And yes, the sources confirm this is an affirmative defense. So the defendant has to prove it.
Right. Burdens on them.
And Texas uses a standard that's pretty strict, rooted in what's often called the Knighton test. The core idea is this. At the exact time of the conduct, the actor, because of a severe mental disease or defect, did not know this conduct was wrong.
Okay. did not know his conduct was wrong. That sounds very specific. It's about knowledge, not control.
Exactly. It's a cognitive test. It's not about whether they could stop themselves, like an irresistible impulse test some places used to have. It's purely about, did they understand at that moment that what they were doing was wrong?
So let's dig into knowledge of wrongfulness. Does that mean knowing it was illegal, like knowing the specific law?
Not necessarily just the legal part, like, oh, the police will arrest me for this. The courts have interpreted it more broadly. It's about knowing the conduct was wrong in a moral or societal sense.
Oh, okay. So even if someone has a delusion, like they think God told them to do it, if they also knew that society or the law considered it wrong,
Then the defense likely fails. They had to be so impaired by the mental disease that they genuinely couldn't distinguish right from wrong in that moment. The disease has to basically obliterate that understanding, not just distort their motives.
So what actually qualifies as a severe mental disease or defect? That sounds like a high bar.
It is an incredibly high bar. Usually you're talking about needing strong medical evidence. Proof of a profound clinical disorder, think, like schizophrenia, severe bipolar disorder with psychotic features, maybe organic brain damage, something that directly impacted their cognitive ability at that specific time.
So just having, say, depression or anxiety, even if it played a role in bad decisions, that's probably not enough.
Likely not, especially since the defendant has the burden to prove it by a preponderance of the evidence. It needs to be demonstrably severe and directly linked to that lack of knowledge of wrongfulness.
And there's a specific exclusion in the law, too, right? Section 8.01b. This seems designed to prevent a loophole.
Yes, this is really important. The law explicitly states that mental disease or defect does not include an abnormality that shows up only as repeated criminal behavior or, general antisocial conduct.
So you can't just say, well, I'm a habitual criminal, therefore I must be insane, or I have antisocial personality disorder, that's my defense.
Exactly. That provision prevents using a pattern of bad behavior or even a diagnosis like psychopathy or sociopathy as the sole basis for the insanity defense.
Yeah.
There has to be something more, some independent evidence of a severe mental defect causing that inability to know right from wrong.
It keeps the focus squarely on cognitive capacity, not just bad character or history.
Precisely.
Yeah.
It maintains that very high standard.
Okay, that sets the bar incredibly high for insanity. Now, let's pivot to intoxication, section 8.04. People often confuse this with capacity issues, but legally, it's treated very differently.
Very differently. And the starting point, the general rule in 8.04a, is crystal clear, and it's a cornerstone of personal responsibility.
Which is?
Voluntary intoxication does not constitute a defense to committing a crime, period.
Mm.
If you choose to drink or take drugs and that impairs your judgment, you're generally held responsible for what you do.
Makes sense. You made the choice to get intoxicated.
Right. But the law isn't completely blind to the fact that intoxication can drastically alter someone's mental state. And that's where the nuance comes in, specifically in section 8.04b.
The mitigation clause.
Exactly. While being drunk or high can't get you acquitted, it's not a defense to guilt. Evidence of temporary insanity caused by intoxication can be introduced. But here's the critical part. Only in mitigation of the penalty.
Mitigation penalty.
Mm.
So it affects sentencing after you've already been found guilty, not whether you're guilty in the first place.
Precisely. It doesn't negate guilt. It potentially reduces the punishment.
Okay, let's make that practical. Say someone's found guilty of, I don't know, aggravated assault. How would using this temporary insanity caused by intoxication actually work during the sentencing phase?
It gives the defense lawyer something to argue. They can say to the judge or jury, yes, my client committed this assault. We accept the guilty verdict. But look, at that moment, because they were so intoxicated they were temporarily insane, they didn't have the same level of control or malice they normally would.
So it speaks to their blameworthiness at the time.
Exactly. It suggests diminished culpability, even if the legal responsibility for the act remains. A jury might hear that evidence and decide to give a sentence at the lower end of the possible range, or maybe recommend probation if the crime allows for it.
And the law requires the court to instruct the jury on this, right?
Yeah.
Section 8.04c.
Yes, if the defense raises this issue and presents evidence, the judge has to tell the jury they can consider temporary insanity from intoxication specifically for sentencing purposes.
And the definition of intoxication in 8.044 is pretty broad, isn't it? It's not just alcohol.
Right. It covers any disturbance of mental or physical capacity that results from putting any substance into the body. Illegal drugs, yes, but also misuse of prescription drugs, sniffing paint, huffing gas. anything that causes that disturbance.
So the overall message seems to be, get voluntarily intoxicated to the point of temporary insanity. You're still guilty of the crime. But the law allows for that extreme state to be considered when deciding your punishment.
That sums it up perfectly. Responsibility for the act, but potential leniency in the penalty.
Okay, let's shift gears now. We've talked about the actor's internal capacity. Now let's talk about their knowledge, or lack thereof. And the law draws a really sharp line between making a mistake about reality, a mistake of fact, and making a mistake about the rules, a mistake of law.
Yeah, and this distinction really highlights how important mens rea, the guilty mind, is in criminal law. What did you actually know or believe?
Let's start with mistake of fact, section 8.02. You mentioned earlier this is a standard defense, not affirmative.
Correct, which means the defendant just needs to raise a reasonable doubt. The prosecution keeps the burden.
And how does it work? What's the core idea?
The idea is that the person, because of a mistake, formed a reasonable belief about a matter of fact. And crucially, that mistaken belief negated the kind of culpability, the mental state, like intent or knowledge that's required to commit the offense they're charged with.
So, it directly attacks the mens rea. If the crime needs you to act intentionally, but your mistaken belief meant you couldn't have formed that intent,
then the culpability just isn't there. The defense applies.
we often hear the example of taking the wrong identical coat from a coat rack, but let's try a different one. Say there's a property line dispute between neighbors, and you hire a contractor. You genuinely believe, based on an old survey map you found in your attic, that this dilapidated fence is on your property. So you tell the contractor, tear it down.
Right.
Turns out the old map was wrong. The fence was actually, say, 1.5 feet onto your neighbor's property.
Okay, classic neighbor dispute scenario.
So the neighbor gets mad, calls the cops, and you get charged with criminal mischief, maybe felony criminal mischief, depending on the fence value, which requires, let's say, intentionally or knowingly destroying someone else's property.
Right, so your defense is mistake of fact. You argue, I didn't intend to destroy my neighbor's property. I reasonably believed, based on that survey, that the fence was mine. Your mistaken belief about the fact where the property line was negates the required mental state for that crime.
But the belief has to be reasonable, right? What if the fence was like brand new, brightly painted, had the neighbor's initials carved into it every few feet, and maybe a keep out sign?
Yeah, then your belief probably isn't reasonable anymore. The statute requires a reasonable belief. If the mistake was unreasonable under the circumstances, the prosecution could argue, okay, maybe you didn't know it was theirs, but you were certainly reckless or criminally negligent in not checking further. You might still be guilty of a lesser offense that only requires recklessness.
Ah, okay. And that brings us nicely to section 8.02b, which talks about lesser included offenses.
Yes, this is a really important qualifier. Even if your mistake of fact provides a defense to the main crime you were charged with.
Like the intentional destruction of the fence.
Right. You can still be convicted of any lesser included offense that you would have been guilty of if the facts were as you mistakenly believe them to be.
How does that apply to the fence scenario? If I reasonably thought it was my fence, tearing it down isn't a crime at all, right?
In that specific fence example, you're right. If the belief was reasonable, there's likely no lesser included offense. But think about cases involving age, maybe. Suppose someone is charged with a felony that requires knowing the victim was under 17.
Okay.
The defendant says, I reasonably believe she was 18. She told me she was. She looked 18. If the jury buys that reasonable mistake of fact, it negates the knowing element for that specific felony.
So they're acquitted of that felony?
Maybe. But they might still be convicted of a lesser included misdemeanor offense, perhaps something like contributing to the delinquency of a minor, because even if the person had been 18, as the defendant believed, their conduct might still have constituted that lesser crime.
Ah, I see. So the mistake doesn't wipe the slate clean entirely. It only negates the specific mental state for the specific crime charged. But you're still on the hook for what you would have been guilty of based on your mistaken view of reality.
Exactly. It's not a get-out-of-jail-free card for all related conduct.
Okay. Now for the other side of the coin. Mistake of law, section 8.03. And you said earlier, this is where the law gets pretty tough.
It really does. The general rule, 8.03a, is one of the oldest legal maxims. Ignorance of the law is no defense. Once a law is properly passed and takes effect, you're expected to know it and follow it.
So if I say, start a small business and accidentally violate some obscure environmental regulation I'd never even heard of, tough luck.
Pretty much. Your lack of awareness, even if genuine, doesn't excuse the violation. Society just couldn't function if everyone could claim ignorance as a defense.
Okay, seems harsh but necessary. Is there any way out?
There is one very, very narrow exception. It's an affirmative defense, meaning the burden is on the defendant, found in 8.03b. It's designed basically to protect people who are actively misled by the government itself.
Misled by the government. How?
The defendant has to prove two things. First, they reasonably believe their conduct was actually lawful. Second, they acted in reasonable reliance on a very specific kind of official statement about the law.
And what kind of official statement qualifies? Can I just say my lawyer told me it was okay?
Absolutely not. Private legal advice doesn't count. The statute is incredibly specific. It has to be either, one, an official statement of law found in a written order or grant of permission from an administrative agency that's actually in charge of enforcing or interpreting that specific law.
Okay, like a written permit from the EPA, maybe?
Potentially if it directly addressed the conduct.
Yeah.
Or option two, a written interpretation of the law found in an opinion from a court of record, or again from a public official who is legally charged with interpreting or enforcing that law.
So we're talking very formal, very official written guidance from the specific government body responsible, not just like a blog post on a city website or something a random official said offhand.
Definitely not. It has to be authoritative, written, and directly from the source empowered to interpret that law. Think about, say, the Texas Commission on Environmental Quality, TCEQ. If you run a factory and you ask TCEQ in writing about a specific emission process, and they issue a formal written opinion letter saying, yes, under current regulations, that process is compliant.
Okay.
And then later, maybe the Attorney General tries to prosecute you under that same regulation, you could potentially use that written opinion from TCEQ as your affirmative defense under 8.03b. You reasonably relied on the official word from the agency in charge.
That makes the contrast really clear. Mistake of fact is about your internal, reasonable misunderstanding of reality, which might negate your intent. Mistake of law is about your misunderstanding of the rules, and it only works if the government itself, in a very specific written way, basically told you your misunderstanding was correct.
That's the essence of it. It protects reliance on official guidance, but otherwise upholds the principle that ignorance is no excuse.
And just quickly, 8.03c. Does the lesser included offense rule apply here too?
Yes, it does. Same logic as mistake of fact. Even if you successfully use the mistake of law defense for the main charge, you could still be convicted of a lesser offense if your actions would have constituted that lesser crime under the law, as you mistakenly believed it to be.
Okay, let's move from internal state's capacity and knowledge to external pressures. Situations where someone's will is potentially overridden by outside forces. Let's start with duress, section 8.05.
Right, and duress is another affirmative defense. So again, the burden of proof is on the person claiming it.
And the core idea is compulsion, being forced to do something.
Exactly. The actor has to prove they were compelled to commit the crime because of a very specific kind of threat.
And the type of threat required seems to depend heavily on how serious the crime was, right? Let's look at the standard for felonies first, in 8.05a. It looks pretty high.
It is high. For a felony offense, the compulsion must come from a threat of imminent death or serious bodily injury to the actor themselves or to another person.
Imminent death or serious bodily injury. So not just any threat. It has to be immediate and severe physical danger.
Yes. Imminent means right now, about to happen. Serious bodily injury means injury that creates a substantial risk of death or causes death, serious permanent disfigurement, or protracted loss or impairment of any bodily member or organ. It's a significant level of harm.
So the classic example, someone holds a gun to your head and says, drive the getaway car or I'll shoot you. That's imminent death or SBI.
Clearly fits. But contrast that with, say, a boss threatening to fire you next week if you don't help cook the books.
Yeah.
That's pressure, maybe even coercion, but it's not an imminent threat of death or serious bodily injury. So it wouldn't qualify as duress for a felony like embezzlement.
Okay. But the standard changes for less serious offenses, for misdemeanors, right? Section 8.05b.
It does. For offenses that are not felonies, the standard is lower. The affirmative defense applies if the actor was compelled by force or threat of force.
Just force or threat of force, not necessarily imminent death or SBI.
Correct. It's a broader category.
Can you give us an example that highlights that difference? Something that would be duress for a misdemeanor, but not a felony.
Sure. Let's reuse the felony example.
Yeah.
Cartel kidnaps your family member, points a gun via video call, says, drive this drug truck now or they die. That's felony duress, imminent death threat.
Right.
Now, for a misdemeanor, imagine a scenario where maybe A really intimidating neighborhood figure threatens to give you a serious beating. Not necessarily life-threatening, but definitely involving force if you don't commit some minor vandalism like spray painting something. A misdemeanor.
Okay.
That threat of a beating, which might not rise to serious bodily injury under the law, could potentially qualify as duress for the misdemeanor vandalism under the threat of force standard. But that same threat probably wouldn't be enough to excuse a felony committed under the same pressure.
That distinction is really important. But there's also this objective test involved, isn't there? The reasonable firmness standard in 8.05c.
Yes, this is critical. The compulsion only legally exists if the force or threat was such that it would render a person of reasonable firmness incapable of resisting the pressure.
So it's not just about whether this specific defendant felt they couldn't resist. It's about whether an average, reasonably strong-willed person would have caved under that same pressure.
Exactly. It's an objective standard. The jury has to ask, was this threat so severe, so overwhelming, that a typical person of reasonable fortitude in that exact situation would have been unable to resist? It stops the defense from being used just because someone is, say, unusually timid or easily swayed. There's a baseline expectation of resistance.
But what if the person kind of put themselves in that dangerous situation to begin with? Does the defense still apply?
No, that's a major exclusion, found in 8.05d. The duress defense is not available if the actor intentionally, knowingly, or recklessly placed himself in a situation where it was probable they would be subjected to that kind of compulsion.
So if you willingly join a violent gang, knowing they use threats to enforce loyalty.
Right. You can't then claim duress when the gang inevitably orders you to commit a crime under threat of violence. You essentially assumed that risk when you joined. You put yourself there.
Makes sense. And one last specific point on duress, 8.05e. What about pressure from a spouse?
The law is very clear here. Simply acting because your spouse told you to or persuaded you to is no defense. Marital relationship doesn't automatically create duress. The only way spousal command works as a defense is if that command itself meets the standard threat level imminent death SBI for a felony or a fourth threat of force for a misdemeanor.
So the spouse has to be making the same kind of threat an unrelated person would have to make.
Precisely. The relationship itself doesn't lower the bar for the threat required.
Okay. Now let's switch from duress pressure from anyone to entrapment, section 8.06. This is different because it focuses specifically on the government's actions, right?
Exactly. Entrapment is all about whether law enforcement or someone acting for them essentially created the crime rather than just uncovering it. And importantly, this is a standard defense, not affirmative. The burden stays with the prosecution.
So what does the defendant need to show to raise doubt here?
They need to show they were induced to commit the crime by a law enforcement agent or someone working for them who used persuasion or other means likely to cause persons, plural, meaning ordinary people, to commit the offense.
Induced. That sounds like more than just giving someone a chance.
Much more. And that's the absolute critical line the courts always have to draw. The statute itself says it in 8.06a. Conduct merely affording a person an opportunity to commit an offense does not constitute entrapment.
So give us the classic example of opportunity versus inducement. Undercover cop scenario.
Right. Undercover officer goes into a bar known for drug activity and quietly asks someone, "Hey, you got anything for sale?" If the person immediately says, "Yeah, what do you need?" and sells them drugs, that's just opportunity. The predisposition, the willingness to commit the crime was already there. The officer just provided the setting.
Okay, so that's not entrapment. What would be?
Entrapment would be more like, imagine an undercover agent or an informant targets someone with no prior drug history. Maybe someone they know is struggling financially. And they don't just ask once. They repeatedly pressure the person over weeks or months. "Come on, man, just this one time. I'll pay you double, triple what it's worth. It'll solve all your money problems. I really need your help." They might appeal to sympathy, friendship, exploit vulnerabilities.
So they're really working on them, trying to break down their resistance.
Exactly. Using persuasion or other tactics that are likely to cause an otherwise non-predisposed person to commit the crime. The focus is on the government's conduct. Did they go too far? Did they essentially plant the criminal idea and overcome the person's unwillingness? If so, that could be entrapment. It's about preventing the government from manufacturing crime.
And the law is careful about who counts as a law enforcement agent, right? Section 8.06b, it's not just uniformed officers.
Right. It covers any peace officer, state or local, federal law enforcement officers, prosecutors, and critically, any person acting in accordance with instructions from any of those officials.
So that includes confidential informants or maybe even just some random person the police asked to help out on a case.
Yes. If they are acting under instructions from law enforcement, their actions can potentially constitute entrapment. The state can't just use private citizens as cutouts to do things that would be entrapment if an officer did them directly.
Got it. The focus is on whether the inducement originated from the state's efforts.
Precisely.
All right. Our final section today looks at defenses that aren't necessarily about a specific mental state or external pressure at the moment of the crime, but more about the actor's inherent status, usually related to age or maybe a specific vulnerability. Section 8.07, Age Affecting Criminal Responsibility, it looks really complicated, lots of numbers and exceptions.
It is very technical, yeah. It basically lays out the entire framework for when a young person can and cannot be held criminally responsible in the adult system versus the juvenile system. We kind of have to break it down by age group.
Okay, let's try that. Where's the first major dividing line? Under 15.
Right. The general rule, section 8.07a, is that a person cannot be prosecuted or convicted for anything they did when they were younger than 15. That's the baseline. But then there's a list of exceptions.
And those exceptions seem to fall into two main buckets, right? Really minor stuff and really serious stuff.
That's a good way to think about it. On the minor end, you have exceptions like perjury, if they understand the oath, certain traffic code violations that don't involve jail time, city ordinance violations, and significantly, misdemeanors that are punishable only by a fine, like maybe a minor shoplifting charge handled with a ticket. 8.07A15.
So for those very minor things, even someone under 15 might face some consequence, usually just a fine.
Correct. The system needs some way to address that conduct. But then you have the other end of the spectrum, the very serious felony exceptions.
This is where a 14-year-old could end up in adult court.
Exactly. Under 8.07A6, if the crime is a capital felony, an aggravated controlled substance felony, or a first-degree felony, and the person was 14 years of age or older when they committed it, the juvenile court has the discretion to waive its jurisdiction and transfer the case to adult court.
That's the big one, the certification process.
That's the certification process. There's also another specific path for transfer related to certain murder cases under the family code mentioned in 8.
Okay, so under 15 is generally juvenile territory, except for very minor stuff or very serious stuff where transfer is possible at age 14. What's the next age threshold?
17.
Yes. Section 8.07b sets 17 as the age where generally the adult criminal justice system automatically takes over. If you commit a crime before you turn 17, you're typically handled by the juvenile court, unless the juvenile court waives jurisdiction, like we just discussed for those serious felonies, or if it's one of those minor fine-only type exceptions.
So 17 is the default age of adult criminal responsibility in Texas.
For most purposes, yes.
And then there's the mandatory rule about the death penalty in 8.07c.
Right. Consistent with Supreme Court rulings, Texas law explicitly states no death penalty for any offense committed when the person was younger than 18. That's an absolute bar.
Okay. Let's circle back to the youngest kids. There's an even lower age limit for those really minor offenses, right? The fine-only stuff. Section 8.07v. Yes. For those specific offenses listed in A4 and A5, the misdemeanors punishable by fine only, or penal ordinance violations, there's an absolute floor. No prosecution is allowed if the child committed the act when they were younger than 10.
So, under 10, complete immunity for things like a ticketable offense.
Correct. The law essentially says a child that young simply lacks the capacity for criminal responsibility, even for those minor infractions.
Okay, this leads us to maybe the most interesting part of the age rules. The middle ground, kids aged 10 through 14, specifically regarding those minor fine-only offenses. Section 8.07e talks about a presumption.
Yes, this is quite unique. For a child who is 10, 11, 12, 13, or 14, if they're charged with one of those fine-only misdemeanors or ordinance violations, the law starts with a presumption that the child is incapable of committing the offense.
A presumption of incapacity. So the court assumes they couldn't do it, legally speaking.
It assumes they lack the necessary understanding, yes. The burden then shifts to the prosecution to overcome that presumption.
And how do they do that? What do they have to prove?
They have to prove, by a preponderance of the evidence, that 51% more likely than not standard again, that the child, at the time they acted, actually had sufficient capacity to understand that the conduct engaged in was wrong.
I understand it was wrong. Not necessarily illegal, right? The law is specific about that.
Very specific. The prosecution doesn't need to show the 11-year-old knew Section XY of the city code. They just need to show the child understood on a basic level that what they were doing was bad or wrong or something they shouldn't do.
Like, did they know taking candy from the store without paying was wrong? Did they know breaking the window was wrong?
Exactly. That fundamental moral sense or understanding of basic rules. If the prosecution can show, more likely than not, that the child did have that basic understanding of wrongfulness, then the presumption of incapacity is overcome, and they can be held responsible for the fine-only offense.
Wow. That's a fascinating legal standard for that age group.
It really is. It
Yeah.
tries to balance accountability for minor wrongs with the recognition of developing capacity in children.
And this idea of capacity ties into the next section too, right? Section 8.08, dealing with child mental illness or disability.
Yes, this acts as sort of a safety net. Again, specifically for those minor fine-only offenses covered in 8.07A5. It acknowledges that even within that 10-14 age range where the presumption applies, some kids might have additional issues.
So what does the court look at here?
The court has a duty to consider if there's probable cause or reasonable basis to believe that the child involved might either be unfit to proceed, meaning they lack the capacity to understand the court proceedings or help in their own defense, or that they lack substantial capacity either to appreciate the wrongfulness of their conduct or to conform their conduct to the law, possibly due to mental illness or disability.
And if the court does find probable cause for either of those, lack of fitness or lack of capacity due to mental issues, what happens?
The court then may dismiss the complaint. It's discretionary.
So it gives the judge an out, a way to say, this child shouldn't even be in this minor penalty system. They need different help.
Exactly. It allows the court to divert kids with significant mental health challenges away from even the lowest level of the criminal justice system and hopefully towards more appropriate support or treatment.
Okay. Now, finally, we get to a very new and potentially very significant defense, Section 8.09. This creates an affirmative defense specifically for victims of trafficking or compelling prostitution. This feels like a major development.
It absolutely is. It reflects a growing understanding of how profoundly victimization, especially in trafficking situations, can impact someone's choices and agency. And yeah, we need to stress the effective date, December 4, 2025. So this isn't in effect quite yet, but it's on the books.
And it's an affirmative defense, so the burden is on the defendant to prove it applies.
Correct. They have to prove two main things. First, that they were, in fact, a victim of one of the specific offenses listed, basically, human trafficking or compelling prostitution under Chapters 20A or 43.05.
Okay, prove victim status. And second,
they have to prove that the crime they are currently charged with was a direct result of being forced, defrauded, or coerced into committing that trafficking or prostitution conduct. The link has to be direct.
direct result. That sounds like it requires a strong connection. And 8.09b lays out some pretty strict conditions for this defense, doesn't it?
Very strict. There are essentially 4 key requirements baked in there. Let's tick them off.
Okay.
1, but for causation. The defendant has to show they would not have committed the charged offense, but for the trafficker's use of force, fraud, or coercion related to the trafficking itself.
Condition 1, but for cause. What's 2?
2, a reasonable person standard, but with a twist. The force, fraud, or coercion used by the trafficker must have been such that it would have compelled a reasonable person in the actor's circumstances to commit the charged offense.
Hold on, reasonable person in the actor's circumstances. That sounds different from the person of reasonable firmness we talked about with duress.
It is different and potentially very significant. The standard duress test, reasonable firmness, is largely objective. How would an average strong-willed person react? This 8.09 standard explicitly tells the jury to consider the actor's specific circumstances.
So what kind of circumstances might that include?
It seems to open the door to considering things like the psychological impact of the trafficking itself, the trauma, the isolation, the dependency, the grooming, the fear that builds up over time. It suggests a more subjective or at least context-sensitive analysis of compulsion than the general duress standard. It feels more trauma-informed.
That's a really interesting distinction. Okay, so but for cause, reasonable person in their circumstances. What's condition 3?
3, no mere opportunity. Similar to entrapment, the defense doesn't apply if the trafficking situation simply provided the chance to commit the crime. The defendant must have been compelled by the force, fraud, or coercion.
Got it. And number 4?
4, exclusions for serious offenses. The defense generally can't be used if the crime the victim committed is itself one of the really serious offenses listed elsewhere in the code, like capital murder, aggravated robbery, etc., unless the victim is only being charged as a party to that offense, meaning they aided or encouraged it, rather than being the main actor.
So it provides a shield for crimes committed as a result of being trafficked, but not necessarily for committing other independent serious felonies while trafficked, unless maybe they were forced into a minor role.
That seems to be the line they're drawing, yes.
And one last practical point from 8.09e. Does the victim need to prove their trafficker was actually caught or convicted?
No, and that's crucial. The defense does not require proof that the person who used the force, fraud, or coercion was ever charged with or convicted of the trafficking offense.
Why is that important?
Because, realistically, many victims escape or are rescued long before their traffickers are identified or prosecuted, or the trafficker might never be caught. This provision ensures the victim's ability to use the defense hinges on their experience of coercion, not on the separate success or failure of prosecuting the traffickers.
That makes it a much more accessible protection for victims then.
Definitely. It focuses on the victim's reality. #outro.
Wow. Okay, this deep dive into Chapter 8 has been, well, pretty intense, but really clarifying, I think. We've traced how the law defines the very edges of criminal responsibility.
Yeah, moving systematically through different concepts.
Right. We started with those internal deficits, like the complete breakdown of knowing right from wrong needed for insanity, or the reasonable mistake of fact that can just erase the required intent.
Then we shifted to those external pressures. Duress, which requires that really high threshold of imminent severe threat.
Or just force for misdemeanors.
Right. And entrapment, which is all about making sure the government isn't the one actually creating the crime.
And finally, we landed on defenses based on status, the incredibly detailed age rules that determine a minor's capacity.
From near total incapacity under 10 to that presumption for 10-14-year-olds up to adult responsibility at 17.
And ending with that significant new protection coming for victims of trafficking, acknowledging the extreme compulsion involved there. It really seems like Chapter 8 is trying to map out all these complex situations where human failing or coercion bumps up against the law.
It really is a fascinating balancing act baked into the code. You see the law trying to hold people accountable, setting high bars for excuses like felony duress or mistake of law.
Ignorance is no excuse.
Right, but you also see it acknowledging genuine limitations on human agency. The insanity defense, however narrow. The nuanced approach to juvenile capacity, the specific protections for trafficking victims. It's constantly trying to weigh accountability against circumstances that might genuinely diminish or negate blameworthiness.
You know, that distinction we picked up on between the objective reasonable firmness standard in duress and the more contextual reasonable person in the actor's circumstances in the new trafficking victim defense. That really sticks with me.
It's a notable difference in phrasing.
It leads to our final provocative thought for you, the listener. Given that the legislature specifically chose to embed that consideration of the actor's circumstances into the compulsion standard for trafficking victims in Section 8.09, does this signal maybe a broader, longer-term shift? Could we see Texas law starting to incorporate more of these contextual, maybe trauma-informed factors into how it defines compulsion or responsibility in other traditional defenses down the road?
Where else might that concept of judging reasonableness based on the individual's circumstances, rather than just a purely objective standard, start to appear in the Penal Code?
Something to definitely chew on as you think back over everything we've unpacked today from this deep dive.
Absolutely. Well, thank you for joining us for this look at Chapter 8.
We really appreciate you tuning in. We'll see you next time on The Deep Dive.